So with respect to sentencing, so I have some comments that I'd like to make. I think it's fair for all of you to understand, just as the lawyers have pointed out, there are certain guidelines I follow as a judge. And some of those things that are said are mitigating. Others I take into consideration, just like any other of my fellow 33 judges here on the bench. Sometimes the word is desire and demand. Those are not in the revised code section 292911 or 292912. I don't say that to minimize any of the comments that were made, but I do take in everything, right? So I don't come up here on the bench without some idea of what the court may use as the tools under the revised code section to move forward with sentencing. And so I'll say to the Woods family, nothing I say here will ever capture the enormity of your loss. This court recognizes that your lives were forever changed on June 3rd of 2024. Understanding your comments, I thank you for them. No sentence I impose today will make you or your family whole again, and you know that. I do want you to know that I acknowledge, even similarly as Mr. Mack said, your courage, your hopes, and today my hope is that this brings some measure of closure for you to continue to move on in your lives. As you continue to navigate the landscape of life without your son, please know that I'm painfully aware of Julian's void in your lives. Justice cannot undo tragedy, but it can affirm that what happened was wrong and that your child's life mattered. And to the Ellis family, you've been here the whole time as well. I do want to acknowledge that this process as well has been painful for all of you. As a family, you must forge ahead and try to understand the nature and gravity of this case. Again, while my sentence must reflect the severity of the crime, I do not ignore that your family too are experiencing loss. And I hope that you find strength in the days ahead. Ms. Ellis, as noted, the jury of your peers has spoken. They have found that although we all have agreed that you suffer from schizophrenia, that you did understand the nature and wrongfulness of your actions as handed down in all of the guilty verdicts by this jury. The power of the American jury system is that it reflects the values of all the community that they represent. And as I sit here as a judge for almost 21 years, as a court, I accept the finding of your peers, and I'll sentence accordingly. The tragic sequence of events of June 3rd of 2024 and that attack, the jury has found was calculated and wholly without justification or reason of any kind. I rewatched every video for preparation for sentencing that was presented during the trial. And I find that it's clear that in that evidence, you are fixated on the very first child that you crossed paths with that tragic day. That tragic day, you chose to end the life of Julian Wood. A life, as we heard today, that was filled with limitless promises. Your choice has inflicted immeasurable pain on the Wood family, on your own family, and as we heard, on the community in which we all live. Mental illness does not excuse what you did. Although it will be taken into consideration when you are sentenced, that you continue to receive ongoing treatment while incarcerated. Ms. Ellis, I hope that you use this time to confront the harsh reality of the actions that you've created here in the courtroom. No sentence that I hand down today can undo the pain that you cause, but justice requires that your actions have consequences. Before concluding with my sentence and outlining what I will hand down today, I do want to take a moment to address an issue that confronts this court and our communities near and far. This tragedy did not occur in isolation. As a society that cares for the members of the community, we cannot continue to ignore the glaring gap in our county's mental health support system. It is not lost on this court that this trial started during Mental Illness Awareness Week, a week that recognizes the importance of meaningful connections, advocacy, and local actions to ensure that adequate mental health services are available to each and every citizen here in Cuyahoga County. Significantly, the medical experts in this case testified on October 10th, a day that was globally recognized as World Mental Health Day, a day that's dedicated to raising awareness around mental disorders and combating their social stigma. It's in this spirit I hope we all continue to confront the gap between the need for mental health treatment and its effective and equitable distribution and provision to all of those in our community. And therefore, I urgently implore our city and county leaders to continue providing facilities and programs that respond quickly and compassionately to those in crisis. The need is dire now than far too many of us realize. The leaders in this county have been discussing this topic for far too long. Please get it done. No family should have to lose a child, and no family should have to watch their loved ones deteriorate because meaningful and effective mental health services were unavailable. The absence of adequate and functioning mental health facilities in our community has tragic consequences. And I call upon our leaders at every level of government to make providing and supporting mental health care a true priority so that others in crisis can be helped before another tragedy occurs. But Ms. Ellis, again, I want to state that while your mental illness was accepted by this jury, it is not an excuse for what you did. The jury found that although you suffer from schizophrenia, you understood the nature and wrongfulness of your actions and handed down their guilty verdict on all charges. When reviewing the sentencing factors as outlined under 29-29-11 and 29-29-12, my job as a judge here is to punish the offender, but also to make sure that the sentence should be proportionate and not demeaning to the seriousness of the offender's conduct and the impact on the victims, and consistent with other sentences with similar crimes. In looking at the seriousness, of course, the child's age and the suffering weigh heavily for this court as well. And so with respect to my sentencing, after taking in consideration all the matters before the court that are appropriate under the principles and purposes of sentencing, the court's going to impose the following sentence. Starting with count 2, as found guilty on count 2 of murder, it's a life with parole eligibility at 15 years. On count 3, the murder charge under the B section, it's life with parole eligibility at 15 years. And those are the maximum sentences that could be handed down on those 2 counts. On count 4, with respect to the Reagan-Toke sentencing guidelines, count 4 and count 8 are both felonies of the second-degree felonious assault. We also speak to count 5, which was the endangering children as a felony of the second degree. And then we speak to count 7 and 6. The state and I have agreed that I will move forward with count 7. Under count 7, under the Reagan-Toke sentencing guidelines on the attempted murder in count 7, the court's going to hand down the maximum sentence of 11 years as the minimum sentence to the indefinite sentence of 16 and a half years. Again, I've outlined the Reagan-Toke guidelines and the reporting requirements for post-release control that will be controlling on all other felonies of the second and first degree, this being the highest level. I've outlined the 5 provisions, as I noted for the record already. And then with respect to the count 4 and 8, the maximum sentence is 8 years. I'll hand down that sentence. Count 5, 8 years. Count 6, 11 years. Count 8, 8 years. And then as indicted, count 10, which would be a 6-month sentence on the misdemeanor charge. regarding aggravated murder and finding the defendant guilty of aggravated murder by this jury, the court's going to hand down a sentence of life without parole. I'll run every other sentence concurrent to life without parole. Ms. Ellis, you'll be given credit to 509 days of the time that you've served. I'll order you in the custody of the sheriff to transport you to Marysville Correctional Facility. I'll also indicate that fines, fees, and court costs will be waived with respect to this sentence. In addition to the verdict that has been handed down by this jury and the sentence that the court handed down, Ms. Ellis, you have a right to appeal both the sentence and the conviction in this case. You can do that by filing a notice of appeal with the clerk of courts within 30 days of this sentence. If you're unable to pay for the costs of an appeal, you have the right to appeal without payment of costs. If you're unable to obtain counsel for an appeal, I'll appoint counsel to represent you. If you're unable to pay the cost of documents necessary, they are provided to you without cost. You have a right to a notice of appeal filed timely on your behalf. And Ms. Ellis or counsel, do you wish to appeal both the sentence and the conviction handed down in this case?
Yes, Your Honor. Note our objection for the record and appoint counsel for the appeal.
I'll note your objection regarding my sentence, and knowing that she's unable to afford counsel, I'm going to appoint the public defender to represent her with respect to her appeal. Again, noting for the record, all counts will be run concurrent to each other, with the life without parole being count one sentence. I'll waive all fines, fees, and court costs, give her credit for the 509 days that she served, in addition to time while she awaits her transportation to Marysville Correctional Facility for Women. Is there anything further from the state of Ohio before we recess?
No, Your Honor.
Anything on behalf of Ms. Ellis?
No, Your Honor.
All right, we adjourn. Thank you.